The case of the abandoned life partner. Okay. Now, in this scenario, we've got life partners when there is no will in existence. Now, today, some people are choosing to forego the legality of marriage, and they choose to have a life partner. And that's the person whom they choose to share property and assets. While it can be comfortable for a while and they can meet your needs, there may be legal snags as time goes on. And this is going to be the final of the 4 horror stories I share with you today. And this involves, we'll call her Cheryl. Cheryl is a 44-year-old female. She is divorced. She has lived with Carl for 15 years, and she considers him to be her life partner. Cheryl has 3 estranged children. She hasn't talked to these kids in years. Both of Cheryl's parents have died. Cheryl has no siblings. Cheryl owns a vacation home in Charleston, South Carolina. She makes about $65,000 a year. She has life insurance, investments, and some savings. Cheryl's home, the mortgage of her home is in her name. Cheryl owns a 2019 Lexus, and she has no will, right? So if Cheryl were to die without a will, her life partner will not receive any of Cheryl's estate, even though they've been essentially living as a married couple for the past 15 years in a state that does not recognize common law marriage. That's a topic for another video. But for this scenario, for this horror story, they live in a state that doesn't recognize common law marriage. And because they're not legally married, the courts are going to divide the estate. That's her home, the vacation home in South Carolina, the car, the savings, etc., among the surviving children, even though Cheryl has not spoken to her children for years, over a decade. Okay. If Carl is unable to purchase the home that he built for having a life with Cheryl for 15 years, if he's unable to buy that home from the children, he's not only going to lose Cheryl through death, but he's also losing the home that he shared with her for so many years. The only assets that Carl may receive is the life insurance money. And that's if Cheryl named Carl as a beneficiary on that life insurance policy. The same applies if Carl was the beneficiary on some of her bank accounts. Now, one way to avoid or minimize the effects of this horror story is by both Cheryl and Carl creating wills that leave their estates to each other. Now, this is not going to completely avoid the risk of, challenges by any of the estranged children, but at least they will have taken the right steps to protect their estates from falling into the wrong hands. And they will also be protecting each other. Living trusts, I also want to mention, are also something to seriously consider to minimize the costs associated with probate, right?